All right. A very good morning, everyone. I think we'll start with this. So, myself, Vijay Rajan. I'm a fourth-year student at National Law University, Jodhpur, and currently serving as the Deputy Convener for Center for Litigation Studies. And it is my pleasure to introduce our distinguished guest speaker today, Mr. Shreyansh Mardia, an accomplished alumnus of our very own National Law University, Jodhpur. Now, with a remarkable career trajectory, Mr. Shreyansh has had a brief yet impactful stint at Virmani and Virmani, New Delhi, where he made appearances at some of the country's most prestigious legal institutions, including the Supreme Court of India, the Delhi High Court, the National Consumer Forum, and Competition Appellate Tribunal. Currently, Sir is practicing independently at Rajasthan High Court, where his practice spans across diverse areas of law. His journey from this very campus to such prestigious legal arenas is an inspiration to us all, and we are honored to have him with us today.
Thank you for this kind interview. Thank you for hosting me today. I'm an alumnus, as you have mentioned, from the batch of 2012. I'm also a fourth generation lawyer in my family. My grandfather, my great-grandfather, and my father, they were all lawyers. So as you can see, I was probably destined to choose this as a profession. I would just like to state that though I have chosen law as my as my career, but I was really interested into the other activities which I actually took part in college, especially the cultural activities. So I am fond of dancing and I'm fond of playing table tennis. I'm also fond of maintaining myself fit. So I'm also into gymming. So yeah, I mean, apart from law, this is what I actually enjoyed doing in college, and yeah, and I also like to listen to a lot of music in my free time. So yeah.
Sir, so reflecting on your time at NLUJ, what was the most enjoyable aspect of your college experience, and what would you suggest to our current students to look forward at NLUJ?
So basically, NLUJ was, I mean, my time in NLUJ was the most transformational year, in my life, because those were the transformational years for each and every student. I think spending half a decade in a college. But if I would, like to reflect upon my time, see, as a student, a college like NLUJ really helps, helps you connect with law, and also it helps you becoming what you really want to do after 5 years. So as a the college was actually the place where you can actually unwind yourself and you can start building yourself, so I mean, I was particularly not very studious, to be honest, but I actually took part in almost all the moot court competitions I was assigned. I used to take part in a lot of cultural activities. In fact, a lot of fests I used to participate in. In fact, during our time, if I'm not wrong, we were the first one to, in fact, win a group dance competition for NLU. It was in RM and Spoculate. So far, nobody actually was able to do it, but we formed a group, for a dance, and then we participated. And in fact, NH65, we were the initial, not the founding members because I was junior at that time, but yeah, it started during our time. And we were the first one to, in fact, participate even in that competition. So yeah, I mean, I had a great time in college, and I still, fondly remember that. And I wish I could, get back the same time, I can, push the time clock back. Yeah.
Sir, so you mentioned that you also participated in a lot of moot court competitions. So, sir, we also have the similar system right now as well, of course. So, one common feedback that we get from our professors these days is that students are focusing too much on the Supreme Court judgments in the moot court aspect, as well as during our courtroom exercises as well. And they are of the opinion that we don't argue from the perspective of facts or the case. We are just too quick to jump on that factor. So, sir, keeping this in context, I wanted to ask if how the moot court experiences differ from the practical litigation experience in the court, and what should be the students taking care of?
See, moot court actually is reflecting upon a student's research. So when we used to participate, even we used to do the same preparation. that you need to show the judge that you have this judgment, that article, this book, that book, everything is in the memo and in the footnotes. But in the real life situation is quite different. You see, it is first the facts and then the law, because judges know the basic laws and they don't need to be cited of the same thing. They are aware of it. They would really like to first hear the facts. But in moot court, because you need to show your skill set in such a way that you have researched thoroughly and therefore you can speak in that way. So therefore it is slightly the reversal in the way you present yourself. But I believe you cannot change that in a moot court competition, because you are ultimately given 10 minutes or 15 minutes and you are judged on that. So I think as far as moot courts are concerned, it has to be the same way. But when you enter the real litigation, it has to be the facts. First you have to establish your case, and only then you can cite the law. So directly jumping to any case law would not be of any help, even when you're arguing a case, because judge would be first asking you, please at least establish your case, and then you put the law before us.
Also, sir, how far do you think moot court experience is helpful in litigation practice ahead?
A lot. It helped me a lot, and I think a person who wants to start litigation needs to start himself. It should be doing moot courts from first semester itself. It really helps you open up. It really helps you answering questions. It really helps you. The basic quality which is required is the presence of mind. When you don't know the answer, how to address. When you know the answer, how to put it in the best way. This you can only learn if you start from the beginning. At the initial stage, you get the opportunity, and moot courts are the best forum for that place, for this. So one should actually grab the opportunity at the earliest if they want to pursue their career in litigation, because it really gives that confidence building, that how you can engage the judge, and you would also know the way you are arguing, whether the judge is even listening or whether he's getting convinced or not. That is also very important to listen also sometimes what the judge is expecting out of you. So it helps you evolve, and ultimately when you come before the real courtroom, you would not be you would not feel unfamiliar. You will be very much into the zone. You will be very comfortable when you are in the courtroom.
Thank you so much, sir, for your insight. Sir, also, we know that you had a brief stint at a law firm in Delhi as well. So would you like to tell us about your experiences over there and how it shaped your legal perspective and how it helped you establish your own litigation career practice?
So see, I got placed in college itself in 2012 when Mr. Virmani had interviewed us. So Mr. Rajiv Virmani, who's a senior counsel, he and Mrs. Virmani, they are running this firm, and this was in fact the best experience in my life because it had truly shaped my career. See, Delhi, it gives you a different professionalism, and the cases which are in Delhi are of different stakes and are quite high stakes. So, and a senior like Mr. Virmani, in the initial time of my career, actually helped me a lot because I'm still following the practices he has taught me in Jodhpur. So, because that was my formation and my initial day in litigation, and Mr. Virmani had guided me throughout. He had helped me hone the skills, and he was so sharp that he would expect you also to be sharp. Even at that age, he had more skills in Word document, which even as student we did not know how to even explore Word document. Even he had knowledge not only in law, but he was very into the gadgets. He knew the shortcuts of all the Word documents, of an Excel sheet. He would teach you how to do the work faster and in an efficient manner. So apart from that, he also helped us how to look into a case, how to approach a case, how to deal with the client, and especially and most important part in litigation is the professional ethics, which he actually emphasized a lot, because these days, as you know, litigation is it has both the sides, and ethics are more often than not are not followed properly. But Mr. Virmani made sure that his associates are ethically on the right page, and he gave a lot of time on that also. So yeah, I had a great experience with Mr. Virmani, and it has truly helped me of what I am today.
Sir, so I get from your experience. And sir, what we hear from our seniors, like current of 5th years, like I'm currently a 4th year student. So what we hear from them is that maybe you guys should sit for placements at this stage, and then maybe you can switch for litigation at a later stage. And by placements, they also encourage us to sit for corporate placements. So as you would know, at NLU we have a big corporate culture as such, and not many people are inclined towards litigation. So do you think this switch is efficient or like feasible if you sit in corporate placements in the start? Like, do you think a smooth transition is possible?
See, in litigation, it is the earlier the better concept. See, people also enter litigation and then they go for LLM. I mean, so, or they want to choose litigation as a backup option. Like, first, let us earn some money in corporate, then we will dive into litigation. So, I think it depends on a person's background and financial status. But if that person can actually survive and has a decent financial background, he or she should not keep litigation then as a backup, because the earlier you move into the practice, the more benefits you'll get out of it. See, if you work for 2 years in a corporate and then you think, okay, now I have sufficient balance to jump into litigation, so you are missing out on the initial 2 years where you could have made a rapport with the judge, or you could have established yourself for those 2 years, because litigation is all about experience. The more you spend your time in courtroom, the more you will be adding to your seniority. So I believe you can take this. See, transformation can be easily done. That's not a problem. But it is upon you. If you really want to make a career in litigation, then it should not be your second option. It should be the first option. As soon as you graduate, you should directly jump into it.
So continuing on this particular aspect only. So, sir, we as students, we face this dilemma as to how to select the seniors under whom we would be working. So do you have any tips to guide us through that?
Yeah. So basically, when you graduate and you have chosen that, okay, you want to really be into litigation practice, initially I would suggest that you should join a senior counsel or designated senior counsel, because they pay also. So they will pay you a good handsome stipend, and which will sustain you enough, which will sustain you in your stay at Delhi or Bombay. And working with a senior counsel, you would be getting briefs of really high stakes. So a senior counsel will initially help you how to research, how to make notes on the case, how to make, prepare a case in a way he will be arguing. So that is the initial requirement. So initially, if a person wants to choose litigation as a career and wants to pick a lawyer, I would suggest it should be a senior counsel. For a few years, you should work with a senior counsel closely, follow him, or become a shadow, because the oratory skills, the way he addresses the court, the way he answers in courtroom, the way he deals with the client, everything you can, really learn from a senior counsel. And then you can inculcate that practice. And then later on, you can shift to a counsel who is not a senior, but he is a counsel with sufficient practice, who is very busy and who needs assistance with associates arguing the cases. See, with a senior counsel, the only flip side is that you will not get the chance to argue the matter, because client is engaging him to argue the matter. But after working for good 1 or 2 years, when you think you have recent exposure of how to deal with how to read the file, how to make notes, then you should switch to a counsel who has a lot of listing. Because if a counsel who has a lot of listing, he has to run from one courtroom to another, he would really need reliable associates who can argue the case on his behalf when he's stuck in another courtroom. That's when you come in. So he might pay you less, but don't go with the objective of earning. You go with the objective that you will be getting exposure. In litigation, you see, if you don't have the orders in your name, you will not be able to sell yourself in market. What have you done? You have no orders. So you have to have effective orders to market yourself that, okay, you are a person who have argued so many cases, so many judgments, so you can also handle these cases. So that opportunity you will get with a counsel who is really busy. All right. So later on, after senior counsel, you should look for such counsels who have a lot of practice, diverse practice, so you can get an opportunity to argue the matter, because that will be your phase when you really want to argue the matters.
Yes, sir. Totally makes sense. So, sir, in this regard, what skills do you think law students should inculcate, or like focus on in adding to their CV, which such senior designated advocates would be finding useful, or like that would make this students stand out compared to the other people who are applying to their chambers?
See, for litigation, CPC and CRPC, now BNS, is the bread and butter. So if you have these two laws, on your hand, I mean, with the clarity of all the provisions, at least the relevant ones, the procedural part needs to be very thorough and clear. So that is the basics they are expecting that a graduate should know, at least from a college like NLU. That if a client comes in, if a case is coming in, you should know what provision to file, what application should be filed under what. Suppose during the pendency of a case, if your client dies, so you should know under which provision of CPC you will move an application in the court to make the legal representatives on record, right? So he will not be expecting you to ask him only, sir, where should I look? You should know, right? So basically, CPC and BNS now, these two acts, you have to have good knowledge. All right. So if you are in college and if you have spare time, you can start, refresh yourself, start refreshing yourself by reading it again and again, in detail, read judgments on those relevant provisions. So if you are good in that procedural part, it will help you also, and it will also help the senior counsel because you will be able to assist him more, right? So apart from the legal knowledge part, the other most important part is the perseverance and consistency part. You have to be really consistent in this profession. See, the result before the judge is different thing, but you have to show your consistency before the judge. You can't go unprepared. Neither you can assist a senior unprepared, right? So, and I think what we are facing these days is a lot of newcomers. They are not keeping patience at the moment. It is their day one and they are expecting themselves to be, like they should get the clients, they should get the brief, they should get the money. It will not happen like this. There's a procedure. It will take time. First, you have to deliver first, right? You have to give first to get first, right? So that's how it is.
Also, all that, Rishabh, if you want to ask a question.
Hello, good afternoon, sir.
Hi, Rishabh. Good afternoon.
Sir, I have one question from the last question Visa asked. Let's say if someone is from any other state other than Delhi, so should they start?
I'm just holding for one second. Can you repeat your question because there's a lot of noise coming in the background, so I'm not able to hear you properly.
Sir, I'll repeat his question.
Yeah.
So basically, he's asking, what is the importance of location when a person is going into litigation? Like if they are from a small town in Uttarakhand, let's say, like not from a metro city like Delhi and Bombay. So how to sustain and thrive in such a circumstance?
So Rishabh, the question which you asked is actually, I can give you my own example only. I'm from Sirohi. I'm not even from Jodhpur. So my father and my grandfather and my great grandfather were practicing in Sirohi. If you know, Sirohi is one of the most smallest district in Rajasthan. Only Mount Abu is the reason why people know Sirohi district, where it is, because Mount Abu is the only hill station in Sirohi. So see, I think, Rishabh, the background of the person from where he comes from is not very relevant. It is what he does with the skill set given in the college. You have to optimize the college, the studies in college. You have to develop that skill set in college itself. So even if you are in Delhi or in Bombay, of course, see, Delhi and Bombay, the locals will have a edge because they have a house, so they don't have to pay rent. They have the locals are there. They have the things and structure in place. You will probably take a year or two to do the same, to adjust. But ultimately, it is upon your own skill set. Even if you are an outsider, but you bring on table something so important that the other locals are not able to do, you will be preferred over others. In litigation, Rishabh, it is always the X factor, which is the point of law and the way you pursue it and argue it. So it is always upon yourself how you prepare your brief and execute it next morning. So basically, I shifted from Delhi to Jodhpur for another reason, because I had to extend my office, because see, all the appellate works come from Sirohi to Jodhpur. And another problem which I was facing in Delhi was that the opportunity in terms of getting the briefs was very limited, because see, that is the only drawback, is that you are an outsider, so not many people will come to you with a brief. And if you don't have a brief, you cannot actually argue the matter in the courtroom to get orders, right? And if you don't have orders, ultimately it comes to the full circle: no order, no brief, no client. So in that situation, I had to shift my practice to Jodhpur. But what I have, as you know, but now I am again going back to Delhi. See, after coming to Jodhpur, I am getting briefs to argue in Supreme Court. So ultimately, we have established, me and my wife, we have established ourselves in such a way that the clients want us only to go to the Supreme Court or other higher forums. We are appearing in NGT Delhi, NCLT, Bhopal. So, but all this is happening because because if you are able to deliver it, the clients would take you anywhere they have the cases, So I think it is upon us as how you deal and tackle with it.
Uh, Thank you, sir. So, sir, I just have a small follow-up question.
Yeah.
Actually, sir, if I want to establish in my home state only, so should I start my practice in my home state only, or should I first go Delhi or Mumbai, Delhi, because there are Supreme Court, High Courts, and a lot of other courts to hone my skills, soft skills, and then come back to my home state for practice.
In my opinion, Rishabh, even to the associates who come to our office for as a fresher, I suggest them to go to Delhi or Bombay. I always recommend them you first work at a place where the work performance and pressure is higher than in a smaller state. It is always better that you work at the best place, which is the Supreme Court or Delhi High Court or Bombay High Court for that matter, in terms of litigation, because that's where you are open up to so many opportunities. You know where you stand. Actually, you see so many good lawyers, and then you take so much from them, and then you can come to your home state to deliver that here. So then that will help you also. You will be treated as a unique person. You will be treated with great respect here also, because then you would be giving to your local state something new which others are not able to give to the bar. So then you would be in fact given preference while passing in order, because in the High Court, the judges these days, they are really looking for counsels who are actually hardworking and who have something different to offer rather than taking dates or simply adjournments, right? So it will be of immense help if you are actually first learning things from outside and then getting it back to your own state.
Yes, sir. So, thank you very much, sir. It was very helpful. Please help me today in decisions.
All right, Rishabh.
Sir, so I have a question similar to Rishabh, but like in a different sense.
Yeah.
So, sir, during my past internships, I've been given two kinds of opinions. So, one advocate was of the opinion that I should start my practice from trial court, because that is where the real I'll get to learn the real gist of law and the procedural aspect. Whereas in High Court, I won't be able to get into such nitty gritties and like not able to polish my skills as such. But at the same time, one more lady advocate was of the opinion that for girls, it is better to start from High Court itself. It is much more better and maybe safer in certain aspects. So, sir, what is your opinion in this regard?
See, the answer to this is join a court which has original jurisdiction. For example, Delhi. I had also chosen Delhi for another reason. Was this only that trial in Delhi also happens in High Court? There's a pecuniary limit fixed, and cases of a certain pecuniary limit will come directly to Delhi High Court. So in Delhi High Court, the trial also happens. So you should learn from the basics, and the basics are in trial court. So the trial courts have the most procedural part which is used. In High Court, when the appeal comes, the brief is already prepared and you are then preparing on the law aspect, right? But if you want to learn more on the procedural part, trial court is the place you have to start. So if you join a court like Delhi or Bombay, they have original jurisdiction. So there the trial happens in High Court itself, which has a very good infrastructure. So ultimately, it is always better if you actually join a counsel who has some trial practice also, so you can oversee a trial, you can understand the nitty-gritties of evidence, the trial stage itself, and how deposition takes place. So all that understanding is very, very foundational and fundamental to build your career in litigation. And then maybe after some time you can choose your area. Like you are done with trials and you really want to practice only in appellate forums and only prepare the brief on law point and argue the matters.
Also, sir, one more advice that we usually get is one should try to attempt the AOR exam, Supreme Court AOR exam, as soon as they can. But then there are also other downsides to it. Like you need to have an office within a certain range of Supreme Court, and like you need to continuously maintain it as well. So, sir, what do you think are the pros and cons of this? Like when one should decide that they should sit for this exam, and like how to just go about it in
See, I
general?
have a lot of friends who are actually in Delhi who are practicing and into litigation, but they have chosen not to give this exam because they believe that, see, AOR is a person who's actually a counsel on record for Supreme Court as per the Supreme Court rules. They are the only person who can file a matter in the court, right? But it is not the case that you can't argue the case in the Supreme Court. So if only you think that you really have so much of drafting work coming in for Supreme Court, that too, it will not happen initially. After maybe a practice of 5 to 6 years, you would make a market for yourself, and then you realize that actually you are getting a lot of work in which you are required to file a lot. So if your filing is so much, then only you should choose to be an AOR, because that will help you, being a filing counsel. Otherwise, there are so many counsels I know who have chosen not to sit for these examinations because they are already getting briefs to argue in Supreme Court. So it's not a mandatory requirement that if you want to establish yourself in Delhi, you have to give this exam to establish yourself. No, it's not required.
All right, sir. And sir, would you like to share some personal experience that you face in your early stages of litigation career? That how did you overcome them?
So see, initially, when you get a case of your own, so for a few days or even before the case is listed, you will not get sleep only because you are supposed to argue that first case, and then that's, you will always think that is going to decide the fate. If you lose, what will happen? If you win, what will happen? So that anxiety is there, and trust me, that anxiety is. I still get anxiety till date whenever I'm arguing the case because I still feel that I'm a fresher only, and I have to argue a case like a proper fresher because that pressure is always there to deliver to the client. So uh, I had faced a lot of issues, especially when a new case is coming to you. You need to cross check and verify what is the remedy which is available to the client, right? Whether you want to file a writ petition, whether it will be a first appeal, whether it will be a second appeal. So for that, you again, as I said, you have to be thorough with the CPC because I have primarily practiced in civil side. So I have to look into CPC for all these things. So initial challenges which a new person in litigation would face would be the forum. Where to go if a case is coming to you, right? And then the second will be how to tackle the bench. What the bench is negative, how would you address the bench, what kind of questions this bench generally ask in such cases. So luckily, I had some seniors in Jodhpur who had actually assisted me in the beginning when I was, new in this profession. So, and when I get a new case, I used to discuss with them, sir, how do I go about it? And then they would give me their opinion, and it really helped me execute the case. So initial jitters were there, see, because you really want to like get that interim order. Initially, since in civil side, there's a concept of stay, and then the final hearing takes place. In Rajasthan, there's a lot of pendency and lot of cases you really need to have the interim order, the stay order at the first hearing itself. And if you're not able to prima facie make out a case for stay, you will not be successful, because once the court issues notice to in your case, then it will take another good 3 to 4 years for the matter to reach in final hearing. And if you're not able to secure that interim order for your client, your case becomes infructuous in the meantime. So you really need to be thorough with the basic practices of how you can make out a case for stay, what would click with the court. So the challenges are only regarding how do you click, how fast can you make out a case for a stay, how important, how efficiently you can make out a case of urgency in your case, that you need some kind of a relief. So for this, initially you might need, I needed assistance from some of the seniors who had helped me, and then you get into the practice, and then you can easily, make out on your own.
Sir, so does working under a senior solve these issues? Like let's say someone is starting from level 1 and they do not have any such backing or contacts with other advocates, and they are starting out just as a junior advocate under a senior, then in such circumstances, is it easier, or like does this help?
It will be very hard in that circumstances, because see, litigation, you can get queries from any aspect, and you are fresher, you would not know only how to answer the client, and you cannot say, I don't know, I am a fresher, so I'll think about it and let you know. You can't answer the client like that, right? So you need to actually have some seniors around you who can actually guide you if such different proposition, comes in, or such difficult clients come in. So you really need to have some nexus or some group of seniors who are there, whom you can approach whenever the need arises. So it's always better if a senior is there to guide you somewhere in this profession. Yeah.
And sir, what skills or qualities do you think are essential for a successful independent practice? And what are the challenges that an independent practitioner faces in the start? Like in terms of setting up a practice, logistical aspects and other aspects, like apart from law, that one usually does not expect.
See, the challenge is, I mean, the real challenge actually is, how do you identify the core issue, in the brief which you are getting, right? I mean, if client might give you one story, but when you start reading the file, it is ultimately a different case. They try to conceal also many things. So you need to really identify the issue again, and you need to really sometimes push hard with the client that he is not telling the correct story, and you need to get the correct story out of him. So one challenge which you get is to first get the facts right. Right? Clients will not give you the entire facts. Sometime after reading the order, the impugn order, you would come to know this has also happened, that has also happened. He has not given you those documents. So your initial due diligence has to start like that only. Like, after reading the impugn order, you have to again call the client to get all the information you can. And the other, I mean, the skill set which is required really for an independent practitioner, is that I think a lot of patience and persistence is required. A lot of patience is required. There will be days when you have no briefs. I mean, you can't then say, okay, there's been 3 days, I have no case, so you will switch your profession, right? So the patience level is harder. I mean, it's really required here. It will really test you, but you have to keep faith in yourself, and you have to really have patience. That there'll be days when there are no clients, and there'll be days when there'll be so many clients that you will not be able to manage the workload. So litigation has, see, this perk, you can control time. You have the time in your own hand. So unlike corporate work, where you have to like receive the emails, you have to reply to the emails, maybe it's midnight or it's early morning. Litigation, and if you're an independent practitioner, this is the best part. You have the time, you can control the time, you can manage your hours. In fact, if you would see the calendar, it is like a school calendar. You have a lot of holidays, you can enjoy yourself in whole June, summers are off, December is off, Holi, Diwali. So it is a very balanced calendar, and I think it helps you recharge. These holidays also required. But yeah, the true challenge and skill, if you can say that way, is patience. You have to be patient. You can't expect that within a year or two you will be, you will be at par with some seniors who are already in practice, right? So, but you have to sharpen your skill. That doesn't, see, for example, if you are not having brief for 2-3 days, that doesn't mean you are sitting idle. You have to be in courtroom. You have to still see and observe the other seniors, and maybe if a similar case comes to you, you can then directly take those orders in your hand. So ultimately you have to observe a lot in this profession.
Let's say I'm a fresher starting out and I'm working under a senior advocate, and I worked under him for a few years. And then at what point will I realize that, oh, I need to shift my practice, like I need to start my independent practice, or like I need to work under someone else? Like, what is that moment of realization, and how did that moment manifest for you?
So after working for good, I think almost 2 to 2.5 years with Mr. Virmani, I had this, feeling, or I don't know, kind of a voice inside. Now you have to argue the matters on your own. Like, you have to argue the matters on your own. So that kept coming in. So whenever I used to assist him, whenever I used to be on his side, I would always feel like I have to also do the same thing one day. I can't just be very comfortable around, only assisting, right? So sometimes what happens is when a person who's associated with senior for a long time, they get very comfortable then doing that role only. So you will have no headache of arguing the matter. All you have to do is brief the senior, and you will of course be getting your your salary or your stipend or your brief whatever portion it is supposed to be given to you as a briefing counsel. So that comfort should not come to you. If once you start getting comfortable in that role, no, okay, my job is done, my notes are done, synopsis is done, I'm going to sleep. That comes, that I think, I personally believe, is the doom for you. That is where you will go down. So you should always feel, even if you're standing next to a senior, that if a judge asks, if he is not there on that day, and even if you're supposed to take a passover, but you should be prepared as if you are going to argue the matter. If the judge even asks you, what is the matter about young man? You and you don't take passover, you argue the matter. That would be the time when you have to really showcase your talent, that you were prepared and you will argue the matter. So my calling came in after almost 2 years, when I realized that I now really want to start on my own, because now I can't be on the sidelines now. I really want to be in the mainstream. So, yeah. And I think it ultimately comes in when you have done sufficient work, you will know that now you know the basics. Now you can actually answer the client's call and you know where to look for. So you will have that feeling in a couple of years. You would get that feeling.
Sir, so recently, I mean, not recently, I would say, but since quite a while, we have this increase in trend that people are focusing more on ADR as well. Like, especially in law schools also, people are trying to participate more in ADR competitions. And sir, in real life also, with such increasing focus on ADR, do you find that the consumer disputes and the commercial transaction cases are increasingly resolved through these mechanisms? And like, how do you see the role of a litigator evolving with this shift?
See, personally in ADR, I mean, I had a very less experience in ADR, because in Jodhpur, for example, there is very less scope of ADR. The matters which I am dealing with, even if there are ADR provisions, we are not using them also, because what happens is, even in ADR proceedings, there are appeal provisions. If you're not satisfied with the order for arbitration, you will file it in district court. Section 34 will apply. Then you will file appeal. Ultimately, litigation only starts. So the mechanism of conciliation and mediation is a far, I mean, it's not close to reality here in Jodhpur, as far as my experience is concerned. So I think it will take some more time for smaller cities to maybe have that practice of ADR to be inculcated. But at this moment, it is not a preferred option, or even the clients don't choose to sit face to face to deal with the situation. So maybe in the smaller cities, there's a lot of ego issues, or people just know each other's background and they don't want to settle it face to face, and they would rather get it done through the lawyers. So yeah, I mean, in the smaller cities like Jodhpur, I think the scope is very limited. So,
Sir, so one more thing that we are often told as a students during our courtroom exercise feedback by our professors is that some introverted students who are not too good at speaking or not too good at expressing themselves, they are often told ki you need to focus on the skills, you need to polish the skills. If you want to be a successful lawyer, you need to be good with speaking and arguing. So, sir, for some people who are naturally hesitant in speaking, how to go about this, how to polish their skills, like apart from taking part in moot court competitions and all, what do you think one must do to hone their skills?
I see. I can only give you my personal experience. I mean, so even in my free time, even till date, I am carrying a copy of Indian Express with me, and I try to learn the new words, the new articles. There are so many phrases, so you have to keep up with the language. And even in your spare time, I think it is always good to have a reading habit. If you keep reading on something, some kind of a newspaper or some other journal, if you want to do, there are so many. I mean, this is how you can actually start creating a good, you know, uh, good dictionary of words which you can use in common parlance. It will also help you in your mood courts or in litigation. See, command over language is a must, but it does not mean that you have to argue all the cases in English. See, in Jodhpur, people argue in Hindi also, and they get orders. So it is not that if your English is bad, so you can't appear in court or you can't argue, in courtroom. People argue in Hindi also, and there is no bar. There's no point in arguing in Hindi. But because they see that others are arguing in English and they also want to, be at the same level. So I believe that self work needs to be done. You can start reading on something, some kind of a journal or newspaper, the Hindu maybe. Every day, if you can make a habit that 1 hour you need to give the time on reading, I'm telling you, after 5 months, you will see that improvement in yourself. You would be playing with words. So yeah, that is one example I can suggest because I am doing it till date. I keep copies with me. People actually have started identifying me in the cafes. They'll see a paper with he will be the person who has a newspaper. So yeah, you can maintain a habit basically of reading.
Sir, now let us say if someone is in litigation, but maybe that thing is not working out for them, then are there other options like go back into corporate or like make a switch into an in-house
See, yeah, you can
counsel?
always you can
Or like
then
what are
either
the options after?
so you can either switch to a litigation team of a law firm, because in that case also you would be doing the groundwork, you'll be doing the drafting work, and then ultimately law firm would engage a real litigator like a counsel from the court to argue the matter. That is an alternative they can always choose. If they are good with research, if they are good with preparing the briefs, drafting, if they're good in drafting, then they can always work in the litigation department or the team of a law firm. Or you can also be an in-house counsel of a law of a corporate giant or any corporate company. Any major company would have a legal team of their own. The in-house counsel does the same thing. They'll have to do the basics, but ultimately they have to prepare and they have to brief a counsel who will appear in the court. So if they're hesitating to appear in the courtroom, they can always do the background work of preparing the brief or briefing a senior counsel from the court. So that opportunity is always there.
Sir, so as someone practicing independently, how do you manage the pressure of client interaction, the case preparation, court appearances, and everything, especially since such high stakes are involved in like commercial and white collar kind disputes that you practice?
So see, it's actually for though I gave you an example that we have a lot of holidays, but you see, if those holidays are not there, we would burn out. So my daily routine is 10 to 5 I'm in court only, and then 6 to 12 a.m. I'm in office for preparing the next day brief. Drafting is also included. So the lifestyle of a litigator is really hard. You can't even do your own personal work from Monday to Friday if you have any work to do. You can't. You have to hold everything for good 5 days. So the pressure is immense, and you really need to you have to delegate the work also to your associates who can start taking off the burden. But the pressure is really high, and in fact you need to make an understanding with the client that they can't keep calling you. So because you are litigator, you can again direct them. They can only call you between this time to this time, right? You can't entertain calls during the court hours because you will be in the courtroom. So, and the client is expecting that you are supposed to be available for him because he has paid you the fees. He will call you anytime, but you have to be stern, you have to be really strict about it. So I make it a point and I tell them at the time of first meeting itself, if I'm taking your case, you will call me only after 5 p.m. If you call me before that, I am not answering your calls. So they know now that they should not call me. So yeah, and the pressure actually after some time you will get used to it. See, if I tell you how we are able to do it, because in NLU during our time we were up pretty much for the same time, preparing for the moot courts, preparing for the memos, preparing for your submission of projects. You are already doing the same thing. You are in the college, you are studying, then you're coming back to your room, you're preparing, right? So I did not have to make a real life time, some kind of adjustment in my daily routine. It was pretty much there in college, and we followed it the same way. So I think for students from our college, it should not be a task. They can actually manage it very easily because you are used to it. So yeah.
And sir, now you establish your independent practice. At what point did you realize that, oh, maybe I should start taking associates now, or like I need more help? So
Basically, I'm still looking. If you would see my LinkedIn profile, I'm still looking for associates in my. So see what happens at certain point, you have so much litigation, you have so many cases listed that you can't attend all the cases. Like, your matters are clashing. You are arguing in one court and your case is called in another court. That is the time when you are supposed to keep associates, because at least that time when you are in one court, your matter should not go unattended, right? It reflects really badly upon you, and you are trying, not justifying the fees you have taken on the client by not attending the case, right? The least you can do is send your associate for a second round or pass over, right? Or prepare your associate and he can argue on your behest. So I think the moment when you have cases in multiple courtrooms, I think that is the time you have to keep associate.
And sir, like, could you highlight a few cases or legal matters that have been significant milestones in your career?
Actually, one of the matters which actually I discussed with Rishabh also, when I had once taken a class on review and constitutional review, and also difference between CPC review, reference, and revision. So I, in the initial year, when me and my wife, we are both lawyers, so when we had just started our practice, we got a case from a person who was actually participating in constable exam. If you know, constables are the lowest of the rung, lowest rank people in police department, and the only requirement for them is they give written exam, which is very basic, and physical test is taken. They should be able to run, to chase the thief or chase the accused. They should run. So in my case, he came from a very poor background and from a very small village from my hometown, and he came in such a condition that I thought that he might not be able to even pay the fees of a lawyer. But his case was very genuine. So when he came to our office, I asked him, what is your issue? He said, sir, I cleared my written examination. I said, fine. Then when I participated in the physical efficiency test, but I failed in the test. So I said, if you have, law is very settled, if you have failed in a test after participating in an exam, you can't challenge it that I failed it. Then otherwise everyone will come like that only. I failed, but I want to challenge it now. So I said, no, sir, I was given the timeline to reach the venue was so short that I was not mentally prepared for it. This was a very unique proposition because I never heard of something like this. So I asked him, why do you say so that you were not mentally prepared for this test? He said, sir, my admit card to participate in the physical test just came in a night before. I was intimated at 5 p.m. that at 5 a.m. next morning, I'm supposed to reach Jodhpur from my village in Siroi, and I have to run 5 kilometers. How do I do that? I have to get certain documents also. So before the run, they check your medical documents also, that you're fit to run or not. So I spent almost the whole night preparing my doctor's appointment and my documents. And I took a bus at 1 a.m., reached Jodhpur at 5 a.m. in a bus. And I slept for half an hour outside the stadium only where my test was supposed to be there. And I was bound to fail because I did not eat anything. I did not drink anything. So this is the fact which we got from him. And I still told him that, see, despite all this, either you should not have participated or you should have, written to the appropriate authority that you are called like this. So we said, don't get your hopes up because Supreme Court is very settled that once you have participated, you cannot challenge the process again once you failed it. We will try to point out the arbitrariness on this procedural part because that is where the court can interfere under Article 226, that the arbitrariness part. And my wife argued this first case. She actually argued it before Justice Bhansali, who is now the Allahabad High Court Chief Justice. And he granted an interim order. He said that his test is actually not done properly. A retest has to be done. For that person, again, a test was conducted by the police department. He was again assigned a chip and a proper timing to come, and he completed his run in the second attempt. And he is now a constable serving in the department. So why it became landmark was after getting this thing done, we got for next 7 to 10 days at least 1,000 plus phone calls because the vacancy was in lakhs. See, this is constable, so the lowest requirement, right? And so much of unemployment in the state. Everybody participated in this test in lakhs, and government actually faltered in this with thousands. They gave admit cards 1 day prior to the test. So we kept getting calls, and that moment we realized I was in a rented apartment then on first floor, and I came out of the balcony. There were 100 candidates standing in line. I have the same problem. You have to file my case. You have to represent me in the case. So that was a very big case for us, and we in fact did not even charge our legal fees. We only charged them the expenses part. So maybe that part, with God's grace, we were able to get them relief also. And वो बोलते ना दुआओं में याद रखना, their good duas only have helped us now where we are at the moment. So yeah, that was a very big case. And thereafter, I mean, we have done a lot of other cases. I think recently there was a case in which we represented IIM Udaipur, and there are other cases in which we have represented a lot of other good institutes. There are a lot of nursing and medical colleges which we are representing, and we are able to secure orders for them because government is arbitrarily not giving them the recognition or the NOC required to run the courses. So we have taken a lot of orders for the nursing colleges, universities, private universities for medical in the medical field. And there was one matter which was in fact assigned by us through the legal aid cell of the college itself. It was Delta Megwal case. I don't know if your predecessor might be knowing about this case. It's a very it was a sensational case because it was a rape and a suicide case. It had come to college. The father of the victim had come to college, and college had assigned a case to me on behalf of the legal aid cell. There we had objected to the appeal filed by the accused who wanted a suspension of sentence. We got his suspension of sentence in the High Court dismissed. He's still behind the bars. So that was another case, very big in terms of its the offense which had taken place. And then recently the honorable court there was another case which was going in the court, and wherein I was asked by the court to assist the rape victim who was a minor and who was unable to get the pregnancy terminated because of the weeks had passed, as per the law. So in that case, state had refused to provide any financial assistance for delivering of the child of the minor rape victim. So I was in the court that day, and court had asked that whether I can assist whether I can take the financial whether I can provide financial assistance to the victim. I said I will do it. So she is due next month, and I will be taking care of all the medical expenses of delivery of the child. So that was the recent one. It was actually published in Bar and Bench, and which had again got us a lot of calls, and from the colleges, from the locals, and it actually from our alumni community also I got a lot of calls. They also want to contribute for this cause. So yeah, this was another landmark case which was there. And apart from that, there were some constitutional issues also which we had actually argued upon. We had challenged wires of this under the PCA Act. There was an amendment made that sanction has to be taken before prosecuting the officer. A new amendment was introduced in the Corruption Act. So which was challenged before the High Court. The wires we had challenged, and court had issued notice in the matter, which is still pending. And yeah, we have argued a lot of other issues pertaining to constitution. Specifically, there's one in service law which talks about if a person is getting a recruitment, so there's last check is the document verification, where he has to disclose if any criminal case is pending against him or not. So there was one case in which a very minor offense, a criminal case was pending, but it never reached the level of moral turpitude, that he should be disqualified because of pendency of a criminal case. So that case also we had argued, and we had argued the court that cases where the moral turpitude is not even involved, and if he was one of the accused, out of hundreds of them, therefore appointment cannot be stalled because of pendency of a criminal case. So the court had granted relief in that case also, and had granted appointment to that person, and he's also now in a government job at the moment. So yeah, there are multiple cases, but these were the few of the bigger ones which I am discussing with you. There are some other. I mean, we also represent a lot of corporates. We are representing consumer. I mean, we are representing clients in consumer cases also, where we go, and there are a lot of issues there. So we are trying to balance it. I mean, when it comes with corporate or with the individuals, we balance the way we want to take fees or how we can provide assistance. You know, we are also registered in the Rajasthan Legal Aid Services and for taking a pro bono case from the courtroom. And I'm also a member of, I think, your college. I mean, our college is legal itself, so which also keeps sending us cases.
Sir, this is so amazing, and like for all of us who are listening to you today, it is such an inspiration that an alumni of our college is doing so great and is serving as such a source of inspiration for us. And sir, with this, I am done with questions from my end, and I would like everyone else if to come forward if they have any questions. Like Rishabh, if you would like to ask something.
Hello, am I audible?
Yes, Isha.
So, sir, I have heard the full interview. It was amazing to know a lot of new things, lot of new diverse topics we have discussed about. So, I just have one more question. It would be a little bit of informal. So that since we will be graduating in next 5 to 6 months and we will be leaving the college. So, I would be asking from you, what would be that one thing or two things, what would be your golden advice to us to keep in mind before graduating, so that once we graduate and enter in our respective profession, we should keep in mind that that can be general to all of the profession. Either if we are going in corporate, in-house, litigation, or judiciary, what should we keep in mind after graduating? Uh, what should be that one of the common things, or whatever you think that we can keep in mind?
I think two things which you should, I mean, really keep in mind when you leave the college phase and when you enter the real life, the career, whichever you're making. You are going to the bank, I say as a bank, and there are others who will be joining corporate. First, I think, is the mental fitness. Second is the physical fitness. Both you need to take care of, because initially you will be loaded with work and you might be facing situation where in depression, you might be lonely also if it is a new place where you're going to. So it is always good that either you have a friend there whom you can you can share things, because uh, initially you will be loaded with work and you cannot keep up with that kind of lifestyle. So I believe you need to keep a mechanism or a time that you need to give to yourself and to your body, that this 1 hour I'm going to work out, this 1 hour I'm going to do yoga. I think this will help you in longer run, because see, if you are mentally and physically fit, then you will in fact you will be able to perform also well in your workplace, and you will also be happy, that there's a good positive energy you have, today you have taken. And I think that is very important, because we forget that we are ultimately human beings, not machines, that we are able to do from 8 a.m. to 12 a.m. There's the whole lifestyle of work and only work. So I guess, Rishabh, you should really not leave any good habit. If in college you are playing a sport, then you should find it soon there also, wherever you're going in Bombay or Delhi, that there's a club which I'll play. At least on weekends, you should spend that much of time on yourself. So I think the time needs to be also spent on yourself. That is what my one advice would be to you.
Thank you very much, sir. I would keep that in mind once I leave college. And also, on behalf of the center, I am really grateful to you for giving your time to us and accepting our invitation.
Thank you,
I
Rishabh.
think Dvija will now move on with the vote of thanks.
Thank you, Rishabh.
So as we come close to this insightful conversation, I would like to express a heartfelt gratitude to Mr. Shreyansh for taking his valuable time to share his incredible journey with us today. Sir, your reflections on navigating the legal field and like establishing a thriving independent practice at Rajasthan High Court have provided us with valuable perspectives on the challenges and reward of a career in litigation. And your wisdom, humility, and passion for law has not only inspired us, but also offered a practical guidance to our aspiring lawyers who are listening to us today. And so we are truly honored to have you with us, and that if we had this opportunity to learn from your experiences. And we look forward to seeing your remarkable impact you continue to make in the legal landscape. Thank you once again, and we really hope to stay in touch with you for future such wonderful sessions as well.
Thank you so much.
Thank you, sir.